Underhill in the matter of harm essentially state the forum Commonwealth and Development Affairs.
Sorry to have kept you. Well, not at all. Well, having reviewed my notes overnight, which I promised I would do, it seemed to me that the best way to proceed this morning was to take Padfield first, followed by provided by law. At that stage, I'll take the court to Dalston. I had said I'd begin with that, but it seems to me that's more relevant than the two matters which follow, which are rational connection and fair balance. So I'll do it in that way, and hopefully I'll be able to cut down a little bit of what I was proposing to say as a result. Can I, and also there are a number of questions which the court asked yesterday, for example, around the licensing regime. Can I respond to those to the extent I'm able to as I go through and as it's most relevant to the issues I'm dealing with?
However suits you, Mr. Underhill, that's fine.
I'm grateful. Can I begin then with Padfield? Now, as it was advanced yesterday, as we understand it, the Padfield argument focused on whether the judge below had engaged at all with Padfield on an individualised basis. We say the response to that is twofold. First of all, properly analysed, it's clear in the judgment that she did engage with Padfield on an individualised basis, considering its application to this case on the facts. But secondly, relatedly, Padfield is about the promotion of statutory purpose in the sense of promotion of the policy and object of the act in question. That's the language from Padfield in the other cases you've seen, not likely impact, which is what it became bound up with in the argument against us. To make good those submissions, can I ask the court to turn up, please, the judgment? I'll go straight to it. Again, of course, note behind tab 6 in the core bundle begins at page 82. Padfield begins at page 98. And you'll see, perhaps just worth seeing how the argument was put below, paragraph 80. Ground 1 contends that the Secretary of State failed to consider whether the individual designation would further, that was likely to further the statutory purpose of those purposes. And in so doing, the Secretary of State acted, first of all, ultra vires the regulation. So that's why you see the language of ultra vires. That was actually the argument that was put. It was that it was ultra vires in a Padfield sense. So there's no error on the judge's part in referring to ultra vires. That was the argument she was faced with. I'll just give you the reference, no need to turn it up, but that's clear from how that ground was summarised in Malone and Friends' skeleton argument below. That's tab 8, page 116. It begins at the core bundle and at page 118. So just in case the court wonders where vires comes from, that's where. And then you'll see it was also put in terms of mandatory relevant considerations and unreasonableness. And common ground is recorded that the Secretary of State was required to comply with Padfield at paragraph 81. I pause there. There was, of course, some debate about the effect of the amendment to Regulation 6, and you saw a slightly cumbersome way in which that's affected by Section 61 of the 2022 Act. But there was no dispute that statutory purpose and promotion of the policy and objects of the Act, the Padfield principle, still needed to be satisfied on an individual designation. And you'll see the point about material considerations of paragraph 82. Then you'll see the question is how these principles interrelate with Regulation 5, that's at paragraph 83. That in itself is relevant insofar as it shows that the judge was very firmly focused on the application of Padfield to the designation question of Regulation 5. And then at 84, a passage which you saw yesterday, you get the reference to the threshold difficulty. So that's the reference to the statutory amendment taking out the appropriateness criterion. And effectively what the judge says is it's quite difficult in some ways to apply Padfield because in one sense the way it's being put seems to be about appropriateness on the individual case. But at the end of the paragraph she makes it quite clear that doesn't shut off the possibility of the argument being correct. It just highlights the difficulty of definition which lies within it. We say that's an entirely fair observation on the nature of the argument in the particular statutory context in which the judge had to consider it. And we say what is absolutely abundantly clear from that passage is that the consideration of Padfield, both generally and on a case-specific level is not in any way ruled out.
Mr. Blundell, speaking for myself, I wonder whether paragraph 84 was necessary to
Well,
the judge's reasoning.
No, I'd entirely and respectfully agree with that, my lord. It's not part of the ratio in any way. It is an obiter comment, an aside, an observation on the nature of the statutory framework. But it's certainly not a part of the reasoning which actually deals with the determination of the Padfield point. That comes later. And what you then have at paragraphs 85 and 86 is a record of the argument as put, and then that's drawn together in paragraph 87. And you'll see there it's put in terms of rationality. Then at 88 she says that's wrong, I don't accept that. This is an argument which involves recasting the exercise mandated by the statute in light of Padfield. And then at 89, true it is that in light of Padfield the discretion may only be exercised where those purposes are promoted. That's what they are. But then she makes this point at 90, but furthering the purpose of encouraging Russia to cease actions destabilising, etc., is not the same as advancing or being likely to advance those particular purposes. So the point she draws, indeed she goes on, importantly, and says that's a characterisation in this consort to put on it, but it is a fact-sensitive exercise and to that extent individual, but not a granular evaluation of likelihood, requiring nuanced evaluation of the kind of facts sought to be brought into play here. So the point she makes is that you have to consider Padfield on the individual case. Will this particular designation promote those statutory purposes? But what you don't need to
Well, it's, even that's not quite right, is it? I mean, it's not really about, at this stage of the argument, you're not looking at whether there's a realistic chance that it will further the purposes. That's not what this part of the argument is about. It's simply about the object intended to be achieved.
Yes.
If it's not likely to, and is clearly misconceived, then you fail not because of Padfield, but because of no rational connection or possibly disproportionality or whatever.
What my lord, I'd respectfully agree.
This may be over schematic, but given the scheme which the judge was following Bank Mellaz, it's not.
It's only fact.
You've slightly understated the argument, haven't you?
Well, I'll embrace that point, my lord, certainly. It's fact that the point is, the way the argument was being put, certainly at one stage, is there's no engagement with Padfield on this case. There's no consideration as to whether Padfield was actually satisfied for this particular designation. So it's fact-specific in that sense, insofar as the judge has to go. But certainly, there's no need to consider likelihood. And when indeed, to the extent that likelihood does come into play, in terms of rational connection, we know from Dalston that you don't look solely at the particular individual designation.
Yeah, well, quite, that's a different point. But,
Exactly.
Yeah.
But Padfield, it's, and this was really my second point, the purpose of Padfield is to look at that, in a sense, propriety of connection. It's not about, actually, is this likely to achieve a statutory aim, but is it truly in furtherance of that statutory aim? Or is it for some completely ulterior motive?
Yeah.
If you were doing it for a completely hidden purpose or improper purpose, and obviously in many cases there is an overlap between improper purpose and Padfield, then you'd fail Padfield. That's what this is about. So, my lord, I respectfully agree. And then, if one moves on to paragraph 91, she says, we say rightly, the function of the regulations is to provide a framework for the statutory purpose, with the purpose in mind, designation criteria are identified. Once someone falls within designation criteria, there's a proper basis for designating them, and Padfield is prima facie satisfied. But that is, of course, not quite the end of the matter. So again, we say in a context like this, where you have a very, very clear statement of purpose in Regulation 4, and pausing there, that's not always the case in Padfield arguments. A Padfield argument will often begin with a preliminary trawl of an entire act to try and establish what the true principle and objects of the act are. You don't need to do that with these regulations. They are stated to be for a very clear purpose.
I mean, on my analysis, maybe I'm overstating it. What the judge says in 91 isn't even quite right. If if the associate has not spoken to the player for 20 years, has fallen out, but the Secretary of State has overlooked that fact or thinks unreasonably, well, 20 years on, they may still have some influence. That's not a Padfield point. As long as the Secretary of State really is still doing it to further the purposes of the anti-Putin purposes, if I can put it that too crudely. But of course, it's slightly blurred because the more unlikely it becomes, the greater the chance, but depending on the case, that it may actually be for some other purpose.
Yes.
So it has unlikelihood has an evidential weight, but it's in principle, I think Para 91 isn't quite right.
Well,
but the error is
she goes too
doesn't
far.
matter from your point of view.
No, exactly. It may be that the judge has put it slightly too high. There are perhaps circumstances in which one could imagine a 20-year gap being deliberately ignored, something of that nature, by the Secretary of State, and coupled with another improper motive. You might put into Padfield.
All right.
But it will depend on the facts. The key point is that there can be no realistic suggestion based on 90 and 91 that she wasn't considering whether this designation could further statutory purposes. And indeed, where I was getting to was to say it's understandable where you have those purposes very clearly set out in Regulation 4, that quite properly she starts with a various point, again, given that was the way the case was put to her.
Well, I was going to say, Mr. Blunt, speaking for myself, I have some sympathy for first instance judges because I suspect, as one often sees, what's happened here is that various different, analytically distinct grounds of public law have actually all been presented to the first instance judge, all under ground 1. And we can see, if you go back to page 98, the title to ground 1 is failure to consider Ms. Khan's individual position.
Yes.
Well, that's not a Padfield argument.
No.
And then you can see from her summary of the grounds at paragraph 80 that various, actually analytically distinct public law grounds were being all swept up under this. I myself am slightly surprised that she then spends a long time. If this was simply a Padfield point, I think it needed one paragraph. That purpose is purpose and there's nothing to do with effect.
Yes.
But I don't lack sympathy for the trial judge because she's dealing, no doubt, with the arguments the way they've been presented.
Well, perhaps to pick up that point, I gave you the reference, can actually show you how it was summarised. It's only got one paragraph. But at page 118 behind tab 8, which is the skeleton from Ms. Khan below, you see the grounds set out. And if you I can just ask the court to read ground 1, it's exactly that point. You'll see that it brings together ultra vires, Padfield, material considerations, and unreasonableness.
Well, we really said all we need to say, haven't we, about Padfield, about Padfield properly considered.
Well, I'm entirely happy to proceed on that basis, yes. You'll see that she goes on to consider the individual circumstances in the rest of it, but if she's gone too far in doing that, then so be it. It's an error which doesn't affect...
Well, some of the points she makes there may well come in at another stage of the argument. Like my lord, I'm not getting at the judge, I'm just trying to get it clear in our own, our own head.
So in response to that point then, respectfully, I agree. That's, in a sense, all you need to meet the Padfield point. Given what's said about rationality of purpose and so on and so forth later on, it might just be worth seeing a couple
Yes, of course.
Paragraphs, which are under this head, but of course flow through the reasoning of the judgment. Yes. I'll take them quickly.
Yes, of course.
She says at 94, well, I suppose 92, just to pick up, there's no evidence in the middle of a paragraph. Indeed, at the start paragraph, you'll see she says, it's accepted the Secretary has got reasonable grounds for pollution involved person, no evidence which makes her inapt to serve the purpose. So that's no negative evidence. 93...
Well, forgive me, paragraph 92, the middle sentence may really contain the essential reasoning.
Yes.
Perhaps all that needed to be said.
Exactly.
Yes.
Padfield does not say anything about individualised consideration, it speaks only to purpose.
Exactly. And that's it. I think the problem is the individual consideration point became bound up with a characterisation, or has become bound up with a characterisation of the judgment, that she's not considered Padfield as it applies to
Yes,
the person.
well, but we've explored that.
You've got that.
See what we think about it.
No, exactly. So I respectfully agree, that is the ratio. If you look further down, and I raise this really for purposes later, you'll see she makes the point at 94 that, of course, you have the ECHR section of the form considering contribution to statutory purpose. And then at 95, the reasons can't be said to be irrational or even unsound, perfectly comprehensible, that the designation is capable of serving a purpose in these ways. And then she lists those ways in paragraph 95, of sending a signal to Ms. Khan and the Russian government and the international community and others in her position, incentivising by the undermining of the entities carrying on those businesses, the government of Russia to change its behaviour, so pressure through the associated person, signalling support for full implementation, 3, and constraining Mr. Khan's ability to act, for example, in relation to transporting assets. Now, she makes an assessment. She says,
What does D mean?
4, so constraining...
Sorry, 4, yes.
Yes, I think Model has in mind 72D.
Well, I think that's probably where she's got it from.
Yes,
I haven't read this against Mr. Reid, but...
So that is the point, that it constrains Mr. Khan's ability to transfer assets to another person because they are themselves sanctioned.
But maybe transporting is probably a slip for transferring, isn't it?
I think that, yes. Or if she means transporting, she means transferring, exactly. I think that's where that comes from. Now, she said maybe they're not the strongest reasons in the world, but it can't be said they don't show the necessary consideration in terms of prima facie purpose. And then at 97, she deals with the efforts of Mr. Khan to put distance between herself and the Putin regime. She said they only go so far. We said this is quite significant. So first of all, she's the wife of Mr. Khan and plainly associated. 2, she's been the recipient of very significant gifts, including that one very shortly before resignation. But then 3, Mr. Khan is at least to some extent an associate of President Putin. Now, in my submission, that puts it relatively mildly, given the piece of evidence I showed the court yesterday. The point I made yesterday is that he was one of the handful of oligarchs identified by President Putin, invited to and attended a meeting at the Kremlin in March 23, specifically at which President Putin made the point that you oligarchs in this room, are the people who have to show loyalty to Russia in the face of Western economic policy against the war in Ukraine. So one might think in that background, and this will be highly relevant when I come to rational connection, that Miss Khan is precisely the sort of associate that rationally it might be thought one should target.
In fact, though, if you look at these, one is new. I mean, one is simply says she's an associate with the meaning of the radiation. We know that. That doesn't advance the argument. 3, 4, and 5 are all about the importance of Mr. Khan, and that's only significant insofar as it affects the position of Ms. Khan.
Yes.
Isn't really 2 the most important of the points?
For Miss Khan specifically, yes.
Well, but it's Ms. Khan. I mean, I thought that's what we're talking about.
Yeah, absolutely, absolutely. The reason I'm focusing on 3 is because part of the attack on rational connection is, and certainly has been, that this is not a designation which is likely to really hit the target or move the dial, as it was put yesterday. Now,
all right, but there are 2 elements to that, aren't there? One is Mr. Khan likely to be influenced, as he's the actual player?
Yes.
But there's also, is Ms. Khan likely to be influenced? Or to put it in, I put that not quite accurately. There's focusing on Mr. Khan and his influence with the Russian government.
Yes.
And there is the separate question of how acting against Ms. Khan will affect Mr. Khan and encourage him to use his presumed influence with the Russian government.
Correct.
And I didn't detect, didn't abandon anything, but Ms Montgomery's submissions yesterday were focusing very much on the second and not on the first. I know there is stuff in the Sturgeon argument, and there's obviously stuff below about, oh, well, Mr. Khan isn't in the inner circle.
Yes.
You've produced your evidence to suggest that actually he is an important player.
Yes, but that is important when one comes, for example, both to rationality of purpose and fair balance, because the significance of targeting an associate of that particular actor carries a particular public weight in the public interest side of the balance, I would say. So it's not a point that I need for Padfield, certainly. I entirely accept.
No, I wasn't really on Padfield.
No.
What interests me in this case is proportionality.
Yes.
And I was just flagging up that I thought that the weight of the argument against you was not so much, though I appreciate it, this point has been made, Mr. Khan isn't a real player.
No.
But that sanctioning Ms. Khan isn't likely to have any influence on him.
My Lord, yes, sorry, I understand the way that my Lord puts it to me now. Yes, that's right, that is the argument against us. But in response to that, we say there are two ways that influence can work. One, through Ms. Khan herself complaining to Mr. Khan, well, look at what has happened to me, you need to use your influence with President Putin to act. So influence from Mr. Khan to Putin becomes directly linked to Ms. Khan's ability to influence Mr. Khan. And second, Mr. Khan himself, and there was a criticism of this, but we say it's misplaced, Mr. Khan himself may quite independently say this is too onerous a burden on my immediate family members, my wife and my children. I am going to seek to use some influence in the Kremlin. I have got influence in the Kremlin. I was there. I'm one of the men who was identified as being central to this Russian loyalty operation that President Putin is pursuing. And so in that case, whilst it's entirely correct that the case against us is premised on Ms. Khan's ability to influence him, actually you can't divorce the two.
And doesn't 4 pick up Miss Khan's own ability to use the substantial sums that were given to her to invest back in Russia? I mean, it may well be that if you're economically straitened because you're invaded another country, assets are cheaper, and that's a perfectly good time to go in and buy. And that, of course, has a good effect on the economic circumstances of that country.
Exactly, and of course you have the point already from paragraph 72D of Mr. Reed's statement. That would be a way where the dual designation of both individuals has a very real effect. So we respectfully agree.
Yesterday I asked you, Mr. Bundle, if it would have been simply enough to achieve the UK government's objective that you designate Mr. Khan.
Yes.
Because then he would be subject to severe restrictions on how he could deal with his property. So he wouldn't be able to make any further gifts, for example, to Ms. Khan.
Correct.
But I just wonder if you have any submission to make to us about what might happen in the real world.
Well,
if she was not subject to designation,
yes.
would there be anything, for example, presumably he couldn't direct her in any kind of legal sense to transfer the property to some third party, but
No.
would there be anything to stop them having a conversation about where they think
No.
might be a good place to invest what's called in the judgment a hugely valuable March gift?
Exactly. My Lord, that's precisely the point.
Would anyone be in breach of the sanctions regulations then?
In my submission, no. And recall, this is an association in the context of a marriage. It is particularly difficult for the law to lift the veil, as it were, on the marriage and what goes on in the marriage. And there has been a concerted effort to distance Ms. Khan from Mr. Khan. You've seen the evidence on that. But it doesn't go all the way. The bottom line is that they are still presented as a loving couple who, over the course of a marriage, as many couples do, have started to lead slightly independent lives. But they are still married. They are still described as certainly in a situation where they love each other and they spend time together and they enjoy spending time together. The idea that the threat of the criminal sanctions in regulation, the asset freeze regulations, for example, regulations 11 to 15, which you saw yesterday, would remove all possibility in that context of the sort of conversation my lord has posited, and indeed the possibility of third-party investment in Russia, my Lord Justice Dingemans has put forward as well, is simply unreal. One has to be realistic here. The Secretary of State, if he were to rely on the bare fact of Mr. Khan's designation in a context like that, would no doubt be told by the international community that he had not taken sufficiently serious measures, and that those particularly limited attacks on the oligarchs directly were capable of subversion and direction around the side in all the ways that are very well known.
And what you're really saying, and speaking for myself, I didn't really pick this up very much from the evidence, but I think the basis for it is probably there, it's not very explicit, is that the March gift, though, which has always been declared, presented as if, but again the evidence isn't quite explicit about this either, as if he thought he was going to be sanctioned and wanted to make sure she had money to live on until he became unsanctioned, which might be for a very long time.
Yes.
Might not only be used to pay the school fees and live the comfortable lifestyle he was used to, but might also be used by being fed back into the Russian economy.
Well,
that isn't, I don't actually see that suggestion anywhere explicitly.
No.
But that's really what's coming out.
We say it's a perfectly fair inference, and in fact the purpose of the transfer, beyond being said it was done under the shadow of the possibility of designation, isn't clear from Ms. Khan's.
See, I agree. She doesn't say quite why she got it.
No.
She just says she got it because he was expecting to be sanctioned.
Exactly.
One view you could take of that would be that the first reason I suggested that she's used to getting money from him, and she may not be able to for the foreseeable future, so you better have it all now.
Yes.
But another might be, I need a pot outside the country which I can deploy for various purposes, including a real risk that I'll put it back into the Russian economy, or some of it.
And the simple point is, the one thing the court does know is that was an irrevocable gift, it is said, and as a matter of fact, that is correct, the documents show.
Yeah.
It was transferred completely to her, legally and beneficially. She's entitled to do with it as she wishes. If she wants to use that either for her own purposes to support herself here, because she can no longer get the money from her husband once he's sanctioned, well, in a sense, that undermines the strength of the sanctioning against him and his supporters. But also, she is perfectly entitled to invest that in the Russian economy. Once it's hers, she can do what she wants with it.
And that would not be a criminal offence.
No.
Unless she's sanctioned herself, is that right?
That's correct, exactly.
It's the second point rather than the first that really brings us within the purpose of the sanctions regime. You can't really suggest that to give a wife money on the basis that the husband is not going to be able to look after her for the future somehow itself, if that was genuinely and only the only reason, and there was no risk of her deploying it in breach of the sanctions regime, to say, oh well, that means it's less difficult to hurt her. I don't quite see that really.
Well, my lord, I understand the point. The simple point I was making under that head, but maybe I don't need it because of the second head, is that certainly it reduces the overall impact of sanctioning particular involved persons. They are able, in advance of the sanctioning, to see what they need to do.
Protect their wife, to protect their children against the effect of sanctions on them. Well,
I entirely accept that in itself is not an improper objective. If one sees sanctions coming down the line, you think, all right, I'll provide for my family, so be it. One might then say, that makes the sanctioning, the designation of the family members all the more important. And certainly when they have this gift, which they can use for any purpose whatsoever.
Okay, well, thank you. That's helpful.
And then in those circumstances, I don't think I need to go further. You have at 98 and 99 the picking up of the likelihood point, but you've got that already. I'll come back to that in a different context later on. So, my lord, against that background, we say the Padfield argument, based as it was on lack of individual consideration, is quite wrong. It was framed as it was by the judge because of how the argument was put in terms of virees. And again, we say entirely understandable. with a statutory purpose so clearly stated that that's where you start. Where else would you start? Thankfully, one doesn't have the task of trawling through the entirety of the regulations and all their many, many provisions. But nonetheless, she did consider whether Padfield was promoted here, and we respectfully agree that really the nub of it is in paragraph 92. That's where you find the ratio on Padfield. The rest is useful for other points. Let's look at this further. That's what I was proposing to say about Padfield. Can I come then, against that background, to the second point, which is provided by law? That, you will see, begins in the judge's ruling at paragraph 103 and onwards. She was referred to both the Gallagher decision and the Bridges case. You were taken to Gallagher yesterday. Can I just take you back to one passage in Gallagher which we say is significant for these purposes? It will be in your volume 2, behind tab 15. You've seen it already, but I just want to focus on what exactly your assumption said here. The relevant passage is at page 674.
Sorry, I'm just thinking of something else. Where are we going?
I'm so sorry, my lord. It's your volume 2 of the authorities.
Yep.
Tab 15.
Yep.
And within that tab, you see it begins at 633. On page 674.
Do you mind, Mr. Blunder, if we just remind ourselves of what Lord Sumption says at 673?
Yes, of course.
At the top of that page.
Yes.
He makes, what to my mind at least, is an important point, that this is a binary question, not a question of degree, and the consequence is that however legitimate its purpose, and however necessary or proportionate it may be to deal with the problem in this particular way, it can't be done, because it's not in accordance with law.
Precisely. So the corollary of the binary test and failing the binary test, if the law fails the binary test, is really quite far-reaching. It will mean all designations in 6.2d would necessarily...
It may be right. There's not a reason for saying it's
No, of course
right,
not.
but nevertheless one has to bear in mind that's the effect.
That's the effect. That's the consequence. I'm fully aware of the lack of attraction in floodgates arguments, and I'm not saying that at all. But it is binary. One has to face the consequences of what the issue is. And I also say, on this argument, one does have to be realistic about the degree of specificity required. So against that background, can I turn over to 674? Paragraph 17, this is under the Strasbourg case law, again you've seen this, he deals first with accessibility. He then quotes one of the founding fathers, John Adams, and deals with the foreseeability points. And about level with letter F, he says this. He makes 3 points. So he says, first of all, a measure is not in accordance with law if it purports to authorise an exercise of power unconstrained by law. I'll come back in a moment to the language used, but it is at a very high level, unconstrained by law. The measure must not therefore confer a discretion so broad that its scope is in practice dependent on the will of those who apply it rather than on the law itself. So high test, unconstrained, broad scope of potential restraints, the law itself. Nor should it be couched in terms so vague or general as to produce substantially the same effect in practice. That's the first point. The second point then is this: the breadth of a measure and the absence of safeguards for the rights of individuals are relevant to its quality as law, where the measure confers discretions in terms or in practice, which makes its effects insufficiently foreseeable. We say the effects here are perfectly foreseeable, but what is key, and the second point, is breadth of measure and absence of safeguards. And then his third point, thus a power whose exercise is dependent on the judgment of an official as to when, in what circumstances, or against whom, and of course this is a who case, to apply it, must be sufficiently, again, not an absolute test, sufficiently constrained by some legal rule governing the principles on which that decision is to be made. And then he contrasts that with the issue of a legal rule imposing a duty take action in some cases. Now that may not raise this problem, but it may raise other issues as to necessity and proportionality. So applying those three core criteria, core issues identified by Lord's assumption to the designation criteria in Regulation 6.2d, first of all, in no sense we say is this a measure which is solely dependent on the will of the official operating it. Can I begin with a submission on breadth? We say the breadth of the discretion is relevant. Of course, at its widest in 6.2d, it's associated with, and we know from Schvidler that Mr. Schvidler was somebody who was associated through a personal and business connection, albeit he was not actually an immediate family member. But then it is defined through subparagraphs 6 and 7. First of all, to somebody taking a financial benefit or an immediate family member, and then as an immediate family member, you have the particular categories that are concerned. Now, of course, the case against me is that's still too broad. But we do say it's relevant to see that the regulation itself funnels down into particular categories and identifies particular categories of even family member who are liable to be caught. So it's not as if somebody's left saying, well, I'm third cousin twice removed, might I be at risk here? They can see that they're a wife and therefore they are at risk.
Sorry to interrupt.
Yes.
How do you deal with the involved, which is the designation power? Because it's not just the people who are within that; it's anyone who's then involved with anyone who's involved.
Yes. So that.
So I mean, very rapidly, you
could have
can hit the whole
associates.
world.
Yes, you could have associates of associates, but
Yeah.
that's not this case. This case is about primary associates. And that is, in my submission, clearly where the gravamen of the provision lies. That's what it's really aimed at. I accept that on its face, it's capable of applying to associates of associates. On a different case, one might have a different issue to deal with, but not on this one.
But if we're just looking at in accordance with law, aren't we looking at just what it means and its application?
Yes, but then you have to look at what the restraints are, and that's my second point. So on the restraints, then it's highly relevant to see how the measure is controlled. So what are the sufficient controls? And this will apply directly to somebody who's an associate of an associate, but also to somebody who's with the primary connection of wife. So first of all, and there are four that I'm going to highlight. First of all, pre-decision, there's control through the application of the proportionality principle. That is applied to all cases on the assumption, and it is an assumption, that convention rights are engaged. That's expressly made clear on the face of the SDF form. Can I just show you that? The SDF form is behind tab 4 of the confidential bundle. The ECHR proportionality consideration is at page 150. If I can just point my lords towards the shaded box, consider whether the designation is compatible with rights under the European Convention protecting the UK under the HRA. For the purposes of this analysis, assume that convention rights apply to the designation. So no need for officials, who may of course probably won't be lawyers, to engage in difficult legal analyses of whether a right is truly engaged or not. They proceed on the assumption that it is. So you get a proportionality assessment of convention compatibility in all cases. That, we say, ensures a case-specific focus on matters which include, as they did here, the four Bank-Malak criteria. So you are directed to look at sufficient important interest, lesser measures, no challenge to that in this case, rational connection, and of course, crucially, fair balance. So all of that is considered, and one might think, in my Lord Justice Dingemans example of an involved, an associate of an associate, that is quite an effective way actually to control the exercise of discretion. Discretion for that category is broader, but it is tightly controlled by proportionality. Secondly, again, pre-decision, a decision maker is subject to the constraints of the common law. and that, of course, includes Padfield and rationality. So, and material considerations and all the rest of it. So this isn't a case where they're directed to do something and they ignore everything else around the side, so they ignore the truly relevant factors. On the contrary, they have to comply with them. Recall the emphasised put in paragraph 17 on the breadth of legal measures that may be used to constrain the exercise of discretion. The law, some legal measure. So all those principles come into play. Thirdly, post-decision, there is an obligation, I don't recall now whether you were shown this yesterday, but there is an obligation under section 22, subsection 3 of SAMRA to withdraw a designation where it no longer fulfills the statutory purpose. Just in case you didn't go through that.
We could if we like, but surely that isn't a constraint.
Well, in my submission it is, and in fact I'll show you a case in due course. Phillips, where Mrs Justice Johnson, at first instance admittedly, did count that as one of the constraints, or one of the controlling factors. It means that even if the discretion is exercised against somebody, there has to be a continuing duty of review on the part of the Secretary of State to ensure it meets those purposes. I say that is a relevant constraint. And that's, of course, at the post-decision phase. So I accept it's not, this may be the point made against me by my Lord, I accept it's not a pre-decision constraint. So it's not a constraint directly on the exercise of the discretion at the time the discretion is exercised, but it is a relevant contextual constraint on the measure being maintained lawfully.
One of the requirements of the principle we're dealing with here, what is the quality of law, is that there have to be adequate safeguards against the risk of arbitrary behaviour and the abuse of power.
Yes.
And courts often look at the entire suite of protections, including post-decision protections.
Yes.
Because they guard against the risk of arbitrary conduct and the abuse of power.
Precisely. It may be that a case is quite finely balanced, and so statutory purpose is satisfied at one point in time, but lessens over the course of time. In which case, relevant that one doesn't even have to make an application. Secretary of State's got a duty.
I mean, I've had to deal with this in the context of the Investigatory Powers Act 2016,
Yes.
which was subject to a full-scale challenge under both EU law and under the ECHR. And what we held there in the Divisional Court, and we were upheld on appeal, was that there is a whole suite of safeguards, which include things like the post-decision review by the Investigatory Powers Commissioner,
Yes.
and the possibility of taking legal action in the Investigatory Powers Tribunal. Now, I think what you're saying is that this is, it's not dispositive, but it's one of the factors
absolutely.
to be taken into account.
It is a detailed statutory scheme which includes a measure to protect the position of an individual, which is imposed on the Secretary of State. A duty of ongoing review. It does happen in other
I suppose my thinking simply was if an arbitrary decision is made, because it's no answer to say that if circumstances change, we may change the arbitrary decision. I certainly wasn't making any point about post-decision for the reason my Lord makes, and I imagine your fourth point was about, which we haven't let you get to, was going to be the right of appeal.
Yes, exactly. Well, and in fact, right of review before you get to the...
All right, right of review and appeal, yes.
Yes.
And I've got no problem with those. I was perhaps just being rather picky about simply saying a provision that if circumstances change, and that you must keep it under review to see that if circumstances change, you will change it, isn't an answer if it's an arbitrary decision in the first place.
No, and of course I accept that to that degree.
That was the only point I was making, which was a rather limited point.
My Lord, I understand. Of course, the corollary then to that point, I think, must be that the pre-decision controls of proportionality, Padfield propriety, rationality, and all the rest of the public law controls provide you with sufficient assurance about at the pre-decision stage. So this is relevant to the general legality of the scheme. And one has to consider the whole scheme, much as one did. I think it was in the Liberty case, yes, the Regulation of Investigatory Powers Act. that you have to consider the entirety of the scheme. Indeed, the decision I'll come to in a moment, Phillips, Mrs Justice Johnson in that case even considered the reporting obligations to Parliament that existed in the early stages of the regime. So Strasbourg can and does look, and so too the domestic courts, at that wider suite of measures within an act, because in itself that demonstrates a concern to ensure generally that decisions are not arbitrary and that there are sufficient remedial measures available to people to avoid them suffering any illegality. My Lord has entirely correctly predicted my other points. So the right of review under section 23, and then obviously the right of statutory review. So administrative review, then statutory review, and of course this is a statutory review of an administrative review decision. What's under challenge in this case is not the original designation, but the administrative review of the designation. So the administrative review is critical, and that actually, in a sense, straddles pre and post decision in one sense, because you have an automatic right to ask for the decision to be reviewed. Most people do, understandably, and indeed Ms Khan entirely rightly asked for that to be reviewed. So that is actually a critical part of the review process, of the legality process, and of the in accordance with the law and foreseeability process, because that means at a stage at which somebody is faced with the day-to-day reality of being designated, they are able to say to the Secretary of State, look, this has these appalling consequences for me. I don't actually have the kind of connection you thought I did. I am now making my representations to you. So that's a person's chance to make representations, to persuade the decision maker to revisit the decision, and that may be effective. In this case, of course, it enabled Ms Khan to say, look, you acted at the point of designation on the assumption that I may have children. In fact, I have 4, and their circumstances are highly relevant. So that was a crucial factor then that's taken into account at the stage of review, which highlights the significance of the review in leading to a measure of control over the exercise of discretion. In truth, when you're looking at decision making for the designation regime, you can't actually stop with designation. You have to take into account, really, as a natural part of the process, the administrative review stage. That's often the most critical bit. Against that background, can I ask you just to go to bridges? There was reference to it yesterday, but I don't think that the court saw it. That is, my bundles are slightly different from yours, I'm afraid, but that is tab 16, which will be in your volume 2. This is a case about the trial in South Wales of automatic facial recognition software.
Yeah.
For police.
We were taken briefly to it, but maybe not to the passages you want.
My apologies. I think you were quite right, you were. And paragraph 55 is the passage I wanted to go back to, just to highlight particularly relevant bits to pick up on what I've just been saying. So 55 begins at page 743. You'll see general principles well established. C, CAT. P there is the Gallagher case. You'll know that already. And then in summary, you have those points. I don't need to go over 1 and 2. That's about accessibility. And indeed, well, 3 is perhaps a transitional note related to 2. The law must afford adequate legal protection against arbitrariness, and accordingly indicates sufficient clarity, scope of discretion conferred. But then 4, where the impugned measures of discretionary power, what is not required is an over-rigid regime which does not contain the flexibility which is needed to avoid an unjustified interference with a fundamental right. And B, what is required is that safeguards should be present in order to guard against overbroad discretion resulting in arbitrary, that's the point I headlined in opening yesterday, arbitrary and thus disproportionate interference with convention rights. And any exercise of power that is unrestrained, to recall the language of law assumption, unconstrained by law, is not in accordance with the law. Then 5, rules need not be statutory, providing they operate within a framework of law and are effective. And then 6, reasonable predictability doesn't mean the law has to codify answers to every possible issue. So what I say about that is, first of all, striking that there is a mirroring in terms of what is required to be protected against arbitrary and disproportionate conduct with the very controls which operate here in terms of convention proportionality. So that's your answer to disproportionate. The proportionality review, which is carried out in all cases. Your answer to arbitrary is a requirement for Padfield propriety and Wednesbury rationality. So the very matters that need to be guarded against are provided for within this system. But notable also that what you don't need is a codification. Of course there is a discretion here, and of course a wide range of cases fall within the scope of a wife who might be designated. But that is not remotely uncommon in the field of public law in this country, or indeed in any of the states of the Council of Europe, subject to the requirements of, in accordance with the law under the Convention. It would convert a discretionary duty, it would convert a discretion into a duty if one had to codify every possible case of its application, and indeed it would be completely impossible in those circumstances. You would then simply end up with many, many hard cases. The ultimate test for the proper application of the discretion and exercise of the discretion in an individual case is proportionality, propriety under Padfield, and Wednesbury rationality.
But why wasn't that a sufficient answer in Bridges itself? Because all of those constraints, and indeed the Data Protection Act constraints, would have applied.
Yes. Well, it will depend also on the nature of the interference and on the breadth of the discretion in question. I couple those arguments, of course, in this case, with the point I began with, my first point, about the fact that the discretion is actually not that wide. Yes, it's wide generally, but that's been funneled down from the associated person criteria generally. So in my submission, it depends on the particular context, and here it is right that there is a discretion left to consider rationality and proportionality in an individual case, but that those should be the guiding constraints when, in particular, the statutory purpose, foreign policy imperative of stopping a war in Ukraine, is so significantly high. That is, in effect, the way that the judge dealt with it, and she dealt with this in particular in her paragraphs 112 to 116. I don't seek to go through that in detail. She effectively adopts that approach. She says at 112 it's not merely accessible, it's clear. That makes it foreseeable. She said the fact that Ms Khan is not arguing that she's not an involved person speaks for the clarity, foreseeability, it's at the top of page 106, and accessibility of the criteria. That itself means the exercise is not open to being simply the will of the individual. Defined hurdles must be surmounted. And then any lack of certainty derives not from the test, but one of the safeguards against its application. The very safeguards she invokes in her first argument and the remainder of the second argument. And then she applies the common law and the ECHR principles in paragraph 113. And so on and so forth through to 160. She cites paragraph 16, Phillips, which I said I would take you to just very, very...
116, that's right.
I'm so sorry.
Yeah, no, 116. I thought you said 16 and I was confused.
Oh, I'm sorry.
No, I'm sure you said 116. I'm sorry. Yep.
It might just perhaps be worth turning that up for the full suite, as it were. That's behind tab 21, which is your volume 3. This was a sanctions case. It was somebody designated as an involved person. So it was a primary principal actor, if you like, not the associated provision. And it was somebody who was effectively producing, as you'll see from the head note at page 912, producing and disseminating audio-visual content in support of Russia's invasion of Ukraine. This point, prescribed by law, you'll see at page 948. There's preliminary arguments there about what you're actually assessing for this provision. You don't need to consider those. You'll see it over the page, at page 141. 2019 regulations are published and readily accessible. They operate in a foreseeable manner. Do not give the Secretary of State anything remotely approaching an unfettered discretion. Of course, again, I stress, this is not an associated with case, so I can't take from it direct support for the associated argument against me. But what it's relevant for is then the assessment at paragraph 144 of what are termed as strong safeguards against arbitrariness. Can I just ask the court to look at 144?
Is it no longer the case that there have to be annual reports?
I think that is correct, my lord. The time for doing them, as he indicates there, was the first 3 years of the operation. So that's now passed.
Was that because the Act itself said only for the first 3 years, or because the provision was repealed?
Can I check? I think it's because it said itself 3 years, but can I check that?
Yes, please do, or they don't take time now, but ask
Yes.
Julia to do it.
I think it's the former point, but I'll check.
Is this decision coming to this court? Do you know?
I'll turn my back from
Again,
that.
dictate time now.
No, of course. No, I'm told no, my lord. Yes, it's the decision was the 12th of January, so it came out very shortly before the hearing below. So, my lord, against that background, we say that the operation of associated with criterion, specifically to wise, which is the category here, is foreseeable, sufficiently foreseeable to be in accordance with the law.
There's a point which Montgomery made under this head, but I think he also acknowledged should be deployed under another head, in which case you'll come back to it later. But about the absence of any guidance or criteria for how, out of the huge pool of associated people, you choose the ones against whom you are going to bring sanctions, and that's whom you're going to designate. That's factually, the factual basis for that is that a very small number of associated people are designated as compared with huge pool that must in principle exist. Do you have anything to say about that, or are you going to come to it later, in which case come to it?
No, I may as well deal with it now. All I can say about that is, as a matter of fact, that is correct. There is no guidance. There is no, as a starting point, it's an obvious point perhaps, but it is still worth making. There's no general requirement in public law, or indeed under the Convention, for guidance to exist in order for an administrative discretion to be lawful.
I understand that, but the point is more about foreseeability.
Yes. And the answer to that is precisely because the circumstances may vary widely. In a sense, one might ask rhetorically, what's the true value of guidance? It couldn't cover all the points. And this goes to the lack of need to codify in point 6 of the summary and bridges. You don't need to codify in order to be foreseeable every single factual circumstance in which a discretion is operated. That's why you don't need guidance to comply with the in accordance with the law point.
Having guidance can,
Provided by law.
sometimes, it can supply the lacuna which there would otherwise be.
Yes.
And that goes back to Silver and ever since. That sometimes
yes.
Policy documents can constitute, quote, law, unquote, for this purpose. But your submission is that it doesn't follow that in every situation the absence of guidance means that you fail this.
Exactly. That's exactly the point. If I could point to guidance here.
Yeah, I think I perhaps artificially constrained or unhelpfully constrained my question by referring to guidance. It was more, Miss Montgomery's point simply is, how do I know why me and not one of the 1,000 other wives
Because you get the reasons for your designation ultimately. So you know the reasons, and
But
you,
if those reasons are reasons which clearly apply to everybody else, isn't there a point about, and this is why I say it may not actually fall under this point, it may fall more appropriately under discrimination, or it's essentially the Bank Mellat point.
Yeah.
Bank Mellat seceded because
Yes.
why Bank Mellat and not any other
else.
bank?
Well,
And if I was a wife and said, why me, when I can see from the published figures, and perhaps from my acquaintance as well, lots of other associates of involved persons aren't being sanctioned.
well, but that
It's
argument,
arbitrary, it's me.
my lord, in my submission, no. The primary guard against arbitrariness is a fact-specific application of proportionality, Padfield, and rationality, as occurs in each individual case. And that will be the primary protection, because that's the precise purpose of those legal controls. But, in any event, insofar as that argument is made, A, you have only a rough indication of the figures, and they are, as I understand it, broadly correct. I think the figure of 48 was given yesterday. I think
It's not significant.
yes, it depends how you cut the issue effectively, but it's roughly that kind of number. But that, I say, is a long way from the Bank Mellat situation, where you literally had one Iranian bank in an Iranian banking sector of some breadth being targeted, and it then looks like specific targeting. But also, in a case like this, the Secretary of State needs the breadth of discretion to decide who to make subject to that designation, in order to best decide how to achieve those high foreign policy imperative purposes. Now, of course, Bank Mellat, there were significant statutory purposes as well, policy purposes in terms of the combat of nuclear proliferation and international terrorism. But this is a case where you don't have, A, you don't have the proper evidential basis to find that there is anything truly arbitrary there at all.
Yeah.
B, you have a fact-specific consideration in this case, which suggests it's definitely not arbitrary. C, it's not a case where the existence of factors in this case in effect demonstrate that nobody else is being looked at in the correct way. And D, you simply do not know how many other wives of oligarchs have been sanctioned. We can provide that information to you if you want it. It's not been an issue before in this case.
Well, that's one point I wondered, actually, was the extent to which this point, which was made for us when Ms Montgomery was explicitly made below. If it had been the high point of the case, I mean, it might have been difficult questions of confidentiality and how what you reveal about other people. But in principle, the Secretary of State might have wished to say, no, your case is not like theirs. Or he might say, there's so many out there, I can't do a complete review and decide exactly which to do. Your case came to my attention and I wanted to do it. There's all sorts of reasons, but this isn't really addressed in the evidence.
No.
And I wondered actually whether an answer might be simply this case hasn't really been put this way before, and it might have been a bit different evidence if it had been.
Lord, it was specifically put below because I made the point that Peteravan, who is the other of the three, has a wife who, as I understand it, has assets and a presence here, has not been sanctioned.
Yes, I see. Well, there we are. Well, the answer maybe it was put before, but I just wanted to explore that on the back of what you said.
Well, I'm certainly not suggesting, and at no stage have I suggested it wasn't put before. What I am saying is you don't have the evidence. That may itself show the significance which has been placed on the issue before. The example which is given of Peteravan, I'm not going to say anything about, because it is a very particular case. I'm not going to comment on individual cases before this court. All I would say is that the sanctioning process, of course, continues, and over time, more and more people are being sanctioned.
Yeah.
I can't comment on individual cases. What you do know is that even on the Learned Friends case, there are at least 48 people who've been designated under the association provision. So it's miles away from Bank Mellat. It's not even close. Bank Mellat was the most extreme example.
But I think we probably. I don't want to spend a lot of time on this, but the point is not really about this exactly about numbers. It is simply saying, given how big the pool is, you might expect there to be criteria with a small c, perhaps not published, but some principles on which you choose who you go after.
Yes.
And there aren't. That may not be fatal, or certainly no published ones.
My answer to that is the principles are effectively the controls of law, so proportionality and rationality. And just to close on this issue, because it is important in my submission to put this correctly in a sense, for the purposes of certainly provided by law, it is, what you do know is that there are many people who have been sanctioned under the associated provision. What you do know about bank Mellis is there was only one Iranian bank in a second.
You've made those points.
And you've got that point. So with my submission, it doesn't go anywhere for this point, it doesn't go anywhere for the other points either.
Thank you.
So that, my lord, is what I wanted to say on in accordance with the law. I said at that stage it would be relevant to go to Dalston because it's most relevant to the next two substantive grounds of appeal, rational connection and fair balance. Can I take you therefore to Dalston? And it will be in your, on my file first of all, I think it's in your volume 3, and it's behind tab 23. And I go to it for three purposes. I'll tell you what they are to begin with so you know where I'm going. First of all, what it says about the approach in law to proportionality. That's been headlined obviously already yesterday, but worth going back to it, given how the arguments went. Secondly, what it says about rational connection. And thirdly, what it says about fair balance. There was obviously a very detailed consideration of the correct approach to proportionality in my Lord Justice Singh's judgment. That begins on page 978 at paragraph 9. I won't go through all of it, but just to take the court to a couple of passages, if I can ask the court to look at page 979, paragraph 13, explaining why passage in the Al-Rawi case, very important of course for closed procedures at common law and all of that, but also in terms of what it said about proportionality, why that's slightly misleading. So the reason is because it may give the impression the court is confined to asking whether it's rationally considered the matters it must confront, whereas the second sentence makes it clear the true principle is that the executive is afforded an especially broad margin of discretion. I've paused there, of course, the punchline on this submission is that the test is for the court itself to apply. It doesn't apply when the reviewing function. But, and this is why I go to this passage, you don't throw the baby out with the bathwater. There is still a very real and significant role for respect for executive discretion. So long the judgment goes on, as it is understood that the court's function is still to decide for itself whether there's been compliance with the principle of proportionality and not simply to apply rationality. First instance, the court won't fall into error. In fact, 14, that the court is the arbiter of proportionality, doesn't mean there's no room for appropriate respect and weight to be given to the views of the executive or legislature. That you get from Bank Mellat itself, and the reference in Lord Sumption's judgment to a large margin of judgment, and by Lord Reid, where he said the intensity of the review varies considerably according to the right in issue and the context in which the question arises. Of course, a principle well established in Smith in this court, and Thomas Bingham's analysis after the roll. Then you get the Lord Carlisle case at 15. Human rights cases, a court of review is not entitled to substitute its own decision for that of the constitutional decision maker, however intense or exacting the standard of review. In cases where convention rights are engaged, it stops short of transferring the effective decision-making power to the courts. Similar point made in Huang by Lord Bingham. And over the page, you get a similar analysis from Ziegler, subject to one qualification. You'll see there a citation from Lord Sale's judgment. This is one of the protest cases of the Supreme Court. Well established on the question of proportionality, the court's a primary decision maker. Well, that's the bit that gets qualified. And although it will have regard to and may afford a measure of respect to the balance of rights and interests struck by a public authority, such as the police, in assessing whether the test at stage 4, that's fair balance, is satisfied, it will not treat itself as bound by the decision of the public authority subject only to rationality review. So pausing there, and this is picked up my Lord Justice Singh's judgment, actually the respect, primarily one says these days, post-Ulster, is according to the public interest side of the balance and all the weight given to the assessment that's made there by the Secretary of State, sometimes with expert input, and certainly applying high state prerogatives like foreign policy. But in fact, Ziegler indicates that you do still have a degree of respect, even for the balance that's drawn. No doubt because the drawing of the balance involves the weighing of the significance of those particular considerations. True it is that on the private side of the balance, my other friend may be right to say that the particular impact on an individual is not something that the Secretary of State has any great margin of deference due to him. But the balance itself still involves the weighing, which is a matter that the Secretary of State, perhaps almost more for reasons of democratic accountability than institutional competence, but certainly both, is apt to carry out. That is then picked up in paragraph 19, where my Lord says that the only part of the passage which perhaps needs clarification is the primary decision maker bit. And the passage read as a whole, it's clear Lord Sales wasn't suggesting the court as the primary decision maker in the sense of the person who makes the underlying administrative or legislative decision, and then reference to Lord Carlisle and Wang. Never has that role, and that's really for good constitutional reasons. That said, the rest of the paragraph makes clear the standard review is not rationality, also makes clear the issue under HRA is not a question of process but matter of substance. Finally, passage makes clear, depending on context, the court may afford a measure of respect to the balance of rights and interests struck. You then get consideration, how you particularly approach some of those issues through the lens of Belmarsh at 21. Carrying on, I won't go through the rest of it, but you see picked up at 22 is the role of the court. On appeal. 28 sets out the third category, that's at page 984. There is then the third category of cases which, in my view, the present two appeals fall. Cases where there's been an assessment of proportionality by a first instance court on the facts of an individual case, and the question is the court's role on an appeal. Then you get a detailed consideration on the CPR. You'll see picked up then at 32, my Lord saying, although there's a spectrum, the court on appeal can't simply substitute its own assessment of proportionality for that of the lower court, nor is it bound by that assessment. The lower court's heard in law. Then further consideration, and then it's summarised, the conclusion of paragraph 36.
Do we need this? I mean, it's only 36. Sorry, it's a bit late for me to be saying this. I don't think there's any dispute, is there, about what the right standard is, and it's there in paragraph 36, and you'll agree which category this comes.
Simply making it clear because there is certainly a dispute as to how the first instance judge dealt with. But on appeal, I understand that's correct. There's no dispute. This is a category 3 case, and that's the way you apply it.
But in relation to the first part of your submission, I think the point you're getting to is that I said that the court role is always one of reviewing the underlying administrative decision.
Yes.
Although, in reviewing it, it has to apply the proportionality test for itself.
Correct.
And I think what you're going to go on to show us is that in this appeal, that's what Mrs Justice Cockerill, you submit, did. And that she didn't err by saying that her role was one of review.
No, it's exactly the point. Can I do that now? You've got the background from Dalston. Actually, sorry, before I leave Dalston, can I take you so that you've got it to rational connection and fair balance, and then I can close the case effectively, because it then leads into those points. Rational connection, you see first of all picked up in connection to the Dalston case itself, and that's at paragraph 114 at page 1002. You'll see at 114 what's being considered as the issue of rational connection as a reference to the arguments as put. And then at paragraph 116, in my view, to take one sense, this is criticism of the argument. one sentence in the paragraph below out of context. Judge well aware the assessment was one for the court, he said earlier in his judgment. The point he was making was that all that was needed is a rational connection between the sanctions measure and the aim. He was also making a common sense point. It would be difficult to demonstrate that any one decision would have the desired foreign policy outcome. And then picked up on that, driven to its logical conclusion, the claimant's submission would mean that if 100 ships are detained, each owner of one ship could say that detaining his ship is not going to be particularly effective or make a material contribution. That would be absurd. It's the overall effect which is important, the attention of each of them.
Well, again, this isn't in dispute, is it? This is what we've been calling the cumulative principle.
Well,
Miss Montgomery went out of her way to say it wasn't what she was saying.
no, but it's very, in my submission, it is difficult then to see where some of the rational connection argument goes. Because one is in a situation with an individual designation where one is carrying out a predictive analysis, an evaluation based on what may be an effective way to proceed in particular circumstances where the exact impact is unknown. And indeed one might think in circumstances where the exact impact is particularly difficult to know. It's difficult to delve into the mind of any foreign regime, or even domestic regime perhaps, and particularly so in the Russian context. So when one comes to look at rational connection, one isn't looking specifically for some evaluation of likelihood. There was reference yesterday to the fact that Ms Khan's designation wasn't going to move the dial. Well, in my submission, that simply can't be said, and that can't stand properly with the analysis on rational connection in Dalston. Then over the page, you see perhaps a general point made about the sanctioning regime at paragraph 1, 2, 3. The risk of stating the obvious, one of the ways in which economic sanctions can be effective is by increasing the disadvantages felt by citizens. In this sense, the aim and purpose of sanctions are not restricted to state institutions or those who exercise political power and influence. In this way, sanctions may provide a peaceful way to impose pressure on hostile states. So again, relevant in the context of rational connection, the method of imposing a designation or sanction on an associated person who is not somebody wielding power themselves in the Kremlin is certainly rationally connected to the aim of achieving those foreign policy objectives. Their balance then picked up in Dalston at 126. Little to say about that. Dalston itself was obviously a very different sort of case. It was about a luxury yacht. Then, if I can pick up the same 2 points just to close off this case, in terms of Schvidler. Schvidler, of course, is a case where the court found that Mr Justice Garnham had applied the wrong approach to proportionality. He had applied a Wensbury review. And indeed, perhaps just when I look at this judge's ruling in this case, you'll see just a couple of the passages. Paragraph 164 show you just how it is with hindsight, but with hindsight, how wide of the mark the assessment was there. You'll see, for example, 164 that the italicised words limiting itself instead to asking whether the decision was one properly open to the executive.
Well, again, I mean, time is comparatively short. Do we?
You don't. I can come back to.
We know what they got wrong there.
Well, I don't. I'll skip those points. It was simply to show you the
made
context.
the same mistake here.
Exactly, and we say they didn't. Then, in that case, let me go straight to rational connection or Schvidler itself, which begins at the paragraph. It's a short section, paragraph 189 on page 1017. And there are 3 points made there. First of all, what's required at paragraph 190 is a rational connection, no more, no less. Does not have to be a perfect fit between the legitimate aim and the means chosen to achieve it, provided there is a rational connection. Secondly, it's an objective test.
Well, would it not be quicker? Should we just read these paragraphs?
Yes, of course, my lord. It's paragraphs 190 to 192.
Read them before, you won't be surprised to hear. Yep.
So 3 points. Don't need a perfect fit. It's an objective test, which means it's immaterial. That's the important thing. Immaterial whether or not it featured in the reasoning process of the decision maker at the time. And thirdly, Secretary of State doesn't have to establish that all other factors relied on are in fact made out. That's relevant when you come to the particular circumstances here. All goes to the point that it's objective and for the court. Fair balance, there is a detailed section on this. There's reference to Bank Mellitt at 206, and then really it's at 208 onwards. Can I ask the court just to read 208 and then 210 to the end?
When you say to the end, you mean to the,
To paragraph 214.
Yep. Yep.
My Lord, against that background then, can I deal first of all with rational connection and then move on to fair balance on the facts of this case? So with both of the cases, we have a challenge at 2 levels. There's a generic attack on the application generally of Regulation 6.2d, both for rational connection and fair balance, and then there's an attack on the facts of the case. Rational connection first, on a generic level, we say plainly there is a rational connection in the establishment of a provision for designation based on association. We say indeed it's impossible really to suggest otherwise. It's dealt with, the rationale generally for association is dealt with in Mr. Reed's evidence. Can I ask you to turn that up? It's a single paragraph behind tab 11 of the confidential bundle at page 317. May I just ask the court to read paragraph 24?
Did you say paragraph 11?
Tab 11, my Lord.
So forgive me.
Sorry, I may have said paragraph,
No,
I didn't mean to, my apologies. Paragraph 24.
Yep.
So you'll see really 4 points made there. One is increasing coercive pressure on an involved person. Secondly, incentivising associates to influence the person's behaviour or distance themselves. Thirdly, incentivising others who are associated or may become associated otherwise not to do so. And fourthly, a reduction of the risk in sanction avoidance, which is really the point I was debating at the outset this morning. And I repeat my submission, it may well be in many cases, and this may be one of them, that the most effective angle of the designation is not actually necessarily, or at least an equally important angle of designation, is not just the designation of the truly involved principal player, but actually the designation of the associate. Because if you see those closest to you being seriously and significantly affected by a measure, that may well do more to change your behaviour than anything else. If you are an oligarch who has been excluded from the United Kingdom, so you're not here anymore, you've obviously had a very serious impact in terms of your own assets in the UK. But once you're back in Russia, you have a completely different situation where you can enjoy your assets there potentially and are outside the reach of the UK authorities. Targeting somebody who remains here in those circumstances will really effectively leave a very powerful tool of influence over that individual. So certainly in terms of rational connection, at the generic level, we say that is completely clear. And indeed the alternative, to find that you couldn't have that sort of, on a rational basis, that sort of designation provision, would totally emasculate the designation regime, lead no doubt to enormous international criticism. We also, though, say on a case-specific level that the rational connection point is clearly satisfied. The starting point, and this is why I've just taken you to Dalston and Schvidler, is that this is an objective matter for the court to decide. I'm not going to go through all the evidence again, you've seen it. But that means the court significantly, as this court found expressly in Schvidler, is not limited either by the reasons considered by the Secretary of State when reviewing the designation, or indeed by the reasons provided in evidence even by Mr. Reid. If the court itself considers there is some rational connection on all the material and evidence available to it, that suffices. We say in terms of the particular matters that Mr. Reid, I'll just pick up his evidence as it was before the court and the court's seen it, and it reflects, we say, the other materials. But in terms of the particular matters he identified, designating, first of all, will send a message to Mrs. Khan about the consequences of receiving the benefits that she has done. And that is relevant because it increases the pressure on her to use her influence over her husband. And of course, you do know from the evidence that she has very substantial influence over her husband because she has, again, very candidly and fully and frankly explained to the court how and when and why he has provided the, frankly, enormous sums of money and gifts that he has. Secondly, I accept that disincentivising her from continuing to obtain a benefit from her husband may have less relevance in this particular case where he's sanctioned himself, but that's not the end of the point. And that goes back to the issue about the March gift that has already been explored in argument today. It is relevant even where you have one individual in a couple sanctioned to sanction the other one too, and not remotely lacking in rational connection in doing so. Indeed, one might think it's demonstrative of rational connection. But also, paragraph B of Mr. Reid at 72 goes on to focus on encouraging others to dissociate themselves from being involved in businesses in those strategically important sectors. So it sends out a signal. It's not an Admiral Byng point, but it's showing people that the UK takes these issues seriously and there are consequences. And again, one only needs to consider what the context for this particular designation regime is with the war in Ukraine to understand why that is important, and in particular important in showing strength of response in response to a particularly bellicose action on the part of an international state actor. Thirdly, we do say it is clear that this will encourage her to put pressure on her husband, or that he will independently seek to use his own influence. And that is where I come back to the point about what that influence is. He's not just anyone. He was at that meeting. He was identified by the regime as being somebody who could play a part in responding precisely to sanctions and the Russian and the Western economic policy on Russia's invasion. No objection, we say, to any of this based on the fact that that might be drawn out more fully in Reid than it is in the SDF. The SDF, in fact, I say, when you look at it, and you've seen it already, I don't need to go back to it, but it's actually simply quite high level in the way that it deals with some of those points, but it doesn't close them off. It doesn't say it's this one thing or the other. It's capable of covering both. And I've made points already about sanctions evasion. So I say for all those reasons there is absolutely a rational connection on the specific facts of this case. Indeed, given the role of Mr. Khan, and given the historic relationship and the nature of the relationship and gifts between the two of them, difficult to see a more rational case. That leaves fair balance, and again I'll try and take it as quickly as I can. Can I just highlight one document that I should have, I don't really need to take you to it, but just so that you've got the full suite. You were shown rightly the SDF yesterday, of course that's in its amended form, so following the administrative review, and that's behind tab 4. There is another document that's part of the administrative review process, which sets out things just in a little more detail by reference to the evidence, which is the administrative review form. That's behind tab 6 of the X confidential bundle. Begin at page 198. And I won't go through it in any detail, but I'll just show you how it works, because really the reasoning is then picked up in the SDF. This is the form that's used, you'll see in fact at the top under the heading, Admin Review Form, section 23 SAMLA. This form is designed to record the analysis of a designation carried out in response to a request for variation, or should be all revocation in section 23. Note there are separate forms used for the other requests. You then see at page 203, the earlier bits set out the law and then they set out the grounds for revocation, etc. And then part B at page 203, details of additional evidence, information, and inquiries. And you then get, you'll see there's lots of footnotes there, the footnotes to each particular issue or assertion take you to submissions, summarised at the end, the end note I suppose, to the submissions and evidence submitted on the part of Ms Carr. So what the decision maker is doing is going through quite carefully each and every one of the submissions, or at least of the principal submissions. Yes, actually every single sentence is captured there, but the key issues as advanced by Ms Khan, and explaining why they either do or do not cause them to change their view on designation.
Can I just ask you, paragraph 5, it makes the point that the National Health Service exists and then there's Ofsted, but we know in this case that Ofsted have said no.
That Ofsted have said no, generally that's right. I think there were at the start 1 or 2 licences granted to enable continuity of healthcare provider, but generally speaking Ofsted are not now providing licences, that's right.
Well, it was just to make the point that it doesn't seem to be much of a point in favour of balance if Ofsted always say no.
Well, the answer to that is they don't always say no. They did provide some licences initially in terms of some of the healthcare that was provided, because there was a concern over the continuity of healthcare providers, and there were 1 or 2 licences provided. I can provide the details if that's necessary. But generally, going forward, I accept it's NHS rather than Ofsted.
But can I just understand the conceptual basis of this?
Yes.
If the expenditure is genuine expenditure on medical bills, which would be presumably pretty well easily demonstrated, what's the justification for denying it on the basis, well, you can put up with the NHS? If you've got the money, no suggestion, it's not like a commercial, it might be somebody else's money, like in an asset free, it's your own money. It's very important you don't spend it to support Russia, but paying it to somebody in Harley Street won't support Russia. What's the justification for Ofsted refusing this sort of perfectly genuine expenditure?
So the justification...
It's just to make life hard for the associate. It must be. It may be permissible, but I just want to be clear about this.
Yes.
That can't be justified on the basis this money may go back into the Russian economy or its evasion. It just goes back on, let's make life as difficult as possible for the family of the involved person without reducing them to destitution.
Correct.
Yeah. Okay.
And it is. And I hope... I think it was suggested maybe I was not putting it high enough yesterday when I opened, but I haven't tried to shy away.
No, you haven't.
The harshness of the regime.
But it's hard. We've been looking at the justification,
Yes.
and we've been focusing quite understandably on particularly the concern about the March payment.
Yes.
But this element of how the designation impacts on the associate and her family isn't really relevant from that point of view. It's just part of the general practice. Oh, I've made my point. I just wanted to make sure I got my thinking on that straight. Yeah.
But I'd entirely agree with that. And there are going to be certain payments which are impermissible because they may support the Russian economy, but certain other payments which are impermissible because the purpose of the licensing regime is not to enable a designated person to continue their previous lifestyle. It's meant to have an impact. And that really is the point that's picked up in Dalston in a number of places, and indeed some of the other cases. And the point I made in opening, sanction without impact is no sanction at all. It's meant to make life hard.
I do understand that. It's just that paragraph 5 is written on the basis that OFSI is a real option going forward, whereas on your submission it's not.
Well, it's not generally being used and going to grant licences every time you say, can I access private healthcare? That's correct. What I say though, and it's similar to the education licence that was granted, initial licences were granted to enable some continuity of provision and then they stopped. I'll be correct if I'm wrong, but that's my understanding on this case. And for example, with the education, you will recall that the youngest son's private school fees for the remainder of his, effectively the remainder of the school year when he was at primary school, were covered by a licence. But then after that, they gave an indication, or at the time they approved that licence, OFSI gave an indication that it was unlikely to be granting any further licences, and indeed that's what proved to be the case, and you've seen the latest application. So OFSI, in terms of those issues which don't go to Russia, as it were, but go perhaps to lifestyle, that's not to downplay the significance of the medical issues. I've seen the evidence, I don't challenge it. But OFSI has enabled transition. That's how the OFSI licences have been applied. But going forward, there is a change, and there's a big change in lifestyle. But what this regime, again, to pick up a point I made in opening, what this regime does of sanctioning and what the protection of the law, including the licensing regime, does, is to ensure that a basic level is met. I'll come back to licensing in a moment on the case-specific issues about fair balance. But that's my response to my Lord's point.
Thank you.
And so on and so forth. I don't propose, unless the court will be assisted by it, to go through every paragraph. I just wanted to show you that actually the SDF is the product of an earlier reasoning process, which is recorded in this form, quite detailed. So again, can I just deal with the fair balance argument in the two ways in which it's put? As regards the generic fair balance argument, of course the test is a high one. It's the Christian Institute Safe Spaces test of needing to show that the application of the law will lead to a breach in all or nearly all cases. Well, we say that's just impossible, to show that generically, this provision doesn't strike a fair balance. The learned friend acknowledged yesterday there will be some cases at least in which the result would be proportionate. We say it's quite clear in the circumstances of what you've seen that this is a provision which is entirely capable of being applied lawfully in the vast majority of cases. There may be cases where it is not disproportionate. One has to look at the facts. But that's precisely what the decision maker does when making the designation in the first place and then reviewing it. You've got my submissions already on the various statutory controls. And indeed, if that submission were correct, it would presumably mean that one of the examples given in argument yesterday about President Putin's girlfriend's designation would also fall, not because it was necessarily disproportionate on its own facts, but because the system as a whole is disproportionate. That can't be right. So that just serves to demonstrate the height of the test. We say nothing on generic. As to the specific case, there's two elements to it, and this is where one gets back into the Dalston issue. So the first point is whether or not the judge below applied the right test. And then secondly, whether there is whether she was wrong, we'd say this being a category 3 test, to find that there was no substantive lack of proportionality. You've got the submissions on Dalston already. you'll see fair balance dealt with in the judge's decision at paragraph, at page 110, to begin with. She frames the start of this analysis by noting at paragraph 139 and 140 that there's no challenge to the less intrusive measures limb.
I'm so sorry to interrupt you. Don't we need to go back to paragraph 36 of the judgment? Because Ms. Montgomery made the submission yesterday at page 91.
Yes.
What the judge in the present case did was to cite Mr. Justice Garner in Schvidler, and that he had heard in his approach.
That's right, she does.
So, for example, paragraph 91 of his judgment is quoted, and in the middle sentence of that, which we looked at yesterday,
Yes.
Ms. Montgomery submits that that was an error of law as found by this court in Schvidler, and therefore the judge, perhaps understandably, because she
Yes.
didn't have the Court of Appeal judgment at that stage, the judge was following an approach which has turned out to be erroneous. So this court has said.
Yes. So in my submission, and I understand that the point in why it's put like that, that's not though what she does, and there's
Right.
two reasons for that. Reason one is if you look on at paragraph 37, she said Mr. Justice Garnham also concluded at 96 that in considering proportionality, the court is not limited to assessing the decision maker's process, thinking or assessment at the time the relevant decision was made. So pausing just there, that of course is directly consistent with the guidance given by my lord in Dalston. So in other words, objective question for the court, you're not limited to the material before the decision maker, not reviewing. So it might be said that actually in Dalston at first instance there's quite a tension because of the case law in Al-Rawi and all the other cases between those aspects. What she does is actually to say I'm not limited. So yes, that's what he said, but I'm not limited. That then makes it critical, and that's my second point, to see how she actually does it at paragraph 140 and onwards. So 139 and 140, that's when she introduces the less intrusive measures test. And of course she says rightly there's no challenge to any of that. I think in my learned friend Skeleton there's criticism of the use of the phrase the Secretary of the Secretary was wrong in paragraph 140, but that's just in relation to less intrusive measures. That's before she gets to proportionality, which is what follows. Then at 141, she says, there is on one side of the balance what I'm bound to conclude is a very heavy weight indeed, that's the public interest. Seeks to achieve very great importance, benefiting many people. It's a weight which cannot be made less by use of less intrusive measures. That weight has then to be balanced against the very considerable negative impacts on Miss Carr, who is subject to designation, and also her family, including her dependent children, who are none less impacted as if they were. That's a straightforward balance she describes there. No suggestion of rationality or anything approaching that at that stage. That's supported, we say, by what follows at 142, where she said the impacts have been set out in some detail in the evidence before me and in the submissions which I've heard. She explained how my learned friend carefully explained the situation around health. Then in the middle of that paragraph, particular emphasis is put on the position of the children, particularly the youngest, aged just 10 at the time of designation. My submission in a moment will be that in substance this absolutely does treat the children's best interests as a primary consideration. That is always, whether this is an immigration, ZH Tanzania, extradition HH case, it's always a question of substance, not form. In substance, that's exactly how they're treated. Then those factors are set out in some detail in the paragraphs which follow. Goes through the treatment of proportionality in the SDF, because of course that was what was beforehand, in a sense, a starting point. But then paragraph 148 is where she begins to draw her conclusions, and the terms she uses are very important. So, and recall here no reference back to the sort of self-limiting role of Mr. Justice Garnham in those Schvidler passages from earlier. Instead, she says, ultimately, while it is impossible not to have sympathy for both the emotional toll and the serious day-to-day difficulties which life as a designated person or child, again, front and centre, of a designated person involved, I conclude, one, first indicator that she's doing it herself, the judge, not the Secretary of State, even giving full weight.
Sorry, I missed it. Well, I've lost weight. Which paragraph
I
are you
tried
in?
to insert so much emphasis on
Which paragraph are you in?
Paragraph 148
Yep.
on page 111, sorry. So I do conclude is the very last line.
Sorry. Oh, I see. Yep. Thank you. Yep.
And then even giving full weight to the personal cost to this family. So again, she gives full weight. She accepts the submissions on weight effectively that were made before her. Again, relevant on all points, both children and the wider issues. Then, which I have had made very clear to me. So again, she's not just relying on the Secretary of State, she's doing the balancing herself. She then says this decision does not fall foul of the fair balance test. That's her making a finding. And then that's picked up again in what follows, 149. As I indicated at the outset, this is a balancing exercise between two very different considerations. Yes, that's what she did. On one side, considerable respect to the Secretary of State, correct, consistent with Schvidler. And what is being said is that the purposes of the highest importance, highest foreign policy imperative, as heavy as it can be. On the other side, at the bottom of the paragraph, individual and emotive effects, individual, concrete and real misery and suffering of an identified small family. It's not really possible to say she could have put it much higher than that. She was acutely aware of what this meant to them. And then she says, notwithstanding the difficulties she notes in 150, that is, however, the exercise which must be done. And she then makes comments about the points made in response at 151. In the middle of 151, the balance does not focus on benefits of Mrs Khan's sanctions. So she's drawing in the other side of the balance, or the benefits of the sanctions regime. 152, again, balancing exercise. She said the mitigations are important. She gives an example of unpersoning, which I think has been criticised, but she's simply showing an extreme example. And then she deals more with the ameliorations in paragraph 153. She is critical of Office for what it did and did not do there, but concludes that by the time the evidence was finalised, granted no fewer than 18 specific licences over the page at the top. These include, and this is my point I made earlier, does include licences for private healthcare, 6 licences for return flights to overseas destinations, private school fees, staff salaries and redundancy payments to former staff members. So a wide range of issues. Then a point about how long this goes on. And then 155, I think my Lord put it in argument yesterday, this was the height of the case on incorrect application. Do conclude the Secretary of State has not failed to strike a fair balance. In my submission, she was absolutely right to put it in those terms, because as Schvidler and Dalston demonstrate, it is still not the case that even on an intrusive analysis of proportionality, that the judge steps into the shoes of the constitutional decision maker. So she had to put it like that. What matters is what comes before. All she's saying there is the decision's right.
Okay. Well, we have your submissions on that.
Thank you. So then that just leaves substance. And again, I've got an eye on the time, so I'll take this as quickly as I can. There were 3 points argued yesterday. The first, it was suggested that the judge showed too much deference to the Secretary of State. Well, the answer to that is Dalston and Schvidler at paragraphs 14 to 15, and indeed Lord Sales and Ziegler over the page 17 and 18. We say it is entirely proper, the approach of the judge on that. Secondly, the position of the children, we say in substance they were absolutely treated as a best interest. The relevance in part of showing you the administrative review form is that you can see there was a detailed consideration as against the submissions that were being made to the decision maker at that time. That informs the SDF. Then you have the judge dealing very fairly and very squarely with the position of the children. It can't be suggested that she was under any misapprehension as to the significance of their rights. And in fact, she said she gave full weight to them. And of course, just to recall a point of law, when the best interests are concerned and are raised, they are treated as a primary consideration. Yes. The court has that, I know, from other cases, but not the primary consideration. And then there is the general point about the general position of somebody in Ms Khan's position. And really, I've been through that over the course of yesterday afternoon's submissions as today. Again, I'll say it again, I'm not suggesting it's not a very hard decision for anyone who is designated, including Mrs Khan. But this perhaps comes back to my Lord's point in relation to some of the healthcare, my Lord's plural point, sorry, in relation to some of the healthcare licences. Sanctions are designed to have an impact, and they are designed, in the case of an associated person, to make life difficult. In part, designed to ensure the full integrity of the designation of the principal, so that you avoid the risk of sanction avoidance and so on and so forth. You avoid the risk of getting a very large gift just before you're designated and using it to invest in the Russian economy and all of that. But it's designed to have a wider impact as well, and that forces the influence on the designated person, the principal, and then in due course on the Russian regime.
Would you accept that it is necessary to a fair balance that there be an efficient and effective licensing regime? I accept that is one element of the fair balance. In my submission, certainly by the time you get to, and the reason I'm being slightly cautious about this is because by the time you get to the decision under challenge in this case, for example, and this is some of the information the court asked me for yesterday, Ms Khan, at the administrative review decision stage, has a basic needs licence. Now, no, I'm talking about principle. I obviously allow you to make your points about the facts. But it might be said that the, well, I think it would obviously be said, if you weren't allowed to feed yourself,
yes,
without breaking the law, that would be disproportionate. That's why the government has set up a licensing regime,
yes.
and I get all that. And simply, but the first building is not just to have a licensing regime; it's got to be one which is efficient and I forget what phrase I use, efficient and effective.
yes. So
that must be right in principle, mustn't it?
Yes, my lord. In my submission, yes, it is certainly a part of the fair balance that you have that sort of license.
Well, it's a necessary part of the fair balance. If you didn't have one, it would be
it's
necessarily disproportionate to take away someone's means of feeding themselves.
It may depend on the precise circumstances. So that's why I'm being cautious. In this particular case, and I'm not fully recognise, I'm not going to get very far in suggesting to the court that it was entirely unproblematic, the position in which Ms Khan found herself at the start.
You're answering the question I haven't yet asked.
Well, I think I can see it going down the train tracks towards me.
Yeah, fair enough.
It's a very obvious
But
question.
I was asking it deliberately, sort of step by step, because
Yes.
I was concerned at a suggestion which might come from your submissions that, well, that's really the responsibility of the Treasury, and if it isn't working, that's not our problem. We can still designate.
Yeah.
And what I was going to put to you as my next step is that if it was apparent that it was not working efficiently and effectively, at a time where either when you were making the initial decision to designate or reviewing it, it would not be appropriate to continue the designation.
Well, if I can take it, and I understand why it's put to me as a matter of principle, if I can take it in a number of stages, so my Lord says at the time of the original designation or at the review stage, of course at the review stage we say it is operating sufficiently, and the decision under challenge in this case is the review
Well, that may be so. Again, you're answering a question I haven't yet asked. I just wanted to understand conceptually whether you are taking the point that it's not our problem as the secretary, as the designating decision maker, that there may be problems, serious problems. Let's assume they are for the moment. If there are serious problems with that, then we will go ahead and designate, and you'll just have to go and sue the Treasury.
Well, the approach of this court in Schvidler was to say if there are issues with licensing, that's something you challenge with the Treasury. That's paragraph 212
Well,
of Schvidler.
I may have some difficulty. But at the moment, forget what was said in Schvidler. I want to have a defence of that position. So I'm not entirely sure that is that Schvidler was confronting this particular point.
So,
Or whether it was or not, just answer
Yes.
in principle.
so well, the answer to the point in principle actually is that there was a sufficiently adequately functioning licensing system.
That's not the answer in principle, that's the answer in fact. In principle, if that wasn't the case, would it be a sufficient answer for the decision maker to say, I'm just going to assume, contrary to the facts or the evidence, that it is operating properly because it ought to, and if it isn't, you can always take proceedings against the Treasury.
So in that case, two answers to my Lord's question. One, it's not a necessary part because the remedy is against the individual decision maker operating that system, and that's the Schvidler point, and that's why it's right to look elsewhere. It's the Treasury who operate that, and the Treasury can be challenged. So if a decision, if a designation decision is taken and it is said there isn't a properly functioning system of licensing, then it is proper to look to the public authority, the different limb of the state, which operates that particular system.
Is it a different limb of the state, by the way? It's
Treasury.
all part of the Crown.
Well, there has been all but one Secretary of State, I suppose.
Well, quite.
Yes.
Speaking for myself, Mr. Bloodwell, it seems to me that the point we were making in 212 is not so much to do with legal personality. It's
No.
to do with what is the relevant act. If you've got a complaint about the
Exactly.
way in which the licensing system works, suppose that the licensing unit was within the Foreign Office.
Yes.
I think the point you're making would still be a point you'd be making. It may not be a good point, but you'd still be making it, which is that if you've got a complaint about the licensing regime, complain about the licensing regime, that doesn't undermine the legality of the decision to designate.
Exactly, because you have in existence, uncontroversially, a licensing regime.
Yes.
But my Lord's point, I think, is slightly different, which is suppose at the point of designation, or at least at the point of reviewing the designation, you know that the people down the corridor, well, let's assume they're within the Foreign Office. Let's get rid of this red herring about the legal personality problem, right? If you know that your colleagues down the corridor in the Foreign Office licensing unit, in fact, are not able quickly to process licensing applications, so that, for example, someone may not even be able to feed themselves without breaking the law. I think my Lord is putting to you, despite what we said in paragraph 212, you reach a point where actually it does affect the legality of the decision to designate or continue designation.
If the point that you had was that it was clear there was in effect no functioning licensing system, so no system to give you that protection against destitution effectively at all, then yes, I accept that would be problematic in the way that my Lord puts it.
Yeah.
However, in this case, that's not the situation at all, and it is necessary to look in this case on how the system is operating.
Well, time is limited, and it's also the case that this is, though points were certainly made, it's
Yes.
not fought, but it's not front and centre
No.
in the way it's put as a legal challenge.
No.
But I just wanted to get the conceptual thing clear in my mind, what your position was, and I think I've got there. You would say that although in principle it would be a ground of challenge to the Secretary of State's decision that he was designating in circumstances where he knew that there wasn't an officey system, or the officey system was completely hopeless.
Yes.
That is not the case. That is not the case here.
Exactly.
And we will have just. I don't think the time is available for you. You can give us the references.
Yes.
But we can see that a number of licenses were done. There were delays. I don't think you're challenging the fact that there were any delays.
No. That's a matter of fact.
But you're saying, I think, firstly, that they are not of a character that reaches the threshold of not having a functioning system.
Yep.
And anyway, crucially, that wasn't the position by the time of the review decision.
Exactly.
And we can look at, it's in the evidence.
You effectively got the
what
checkbox.
licenses were granted, what time they took.
and perhaps it's important to indicate why I made the submission I did in accepting that if it was clear you had no system or truly no functioning system at all, and it has to be at that sort of level, then what you're doing is you're precluding anybody. You're effectively creating state-enforced destitution, and you're probably into the sort of situation, you risk being into the sort of situation that the court has considered sometimes in the context of, for example, the Q case and asylum seekers and all that kind of situation. That's what was at the back of my mind with the court's questioning going down that line. However, that's not what you have here. You have a system which certainly operated with delays at the start. The reference to why those delays existed and what they were like and what actions were taken in response is the final paragraph of Mr. Reed's statement. I appreciate time is short, but it might just be worth the court seeing.
Yes, of course. Well, let's just see.
Page 341 in confidential behind tab 11.
I think you were also going to tell us what form the orders take in terms of provision for food from the start.
Yes, so I can answer that question now. And the instructions have come to me while as I arrived at court this morning. So could I'll give the headline now, but could I ask permission overnight to put in a short note answering the court's points on those so you have it from me in a clear form?
Let's hear what the headline points are.
Yes, you may not need it if I've given you the headline. The headline point is there isn't a general licence on basic needs. So that's simply as a matter of fact. The intention is that basic needs licence applications are dealt with quickly, and I am told on instructions that there is now provision as a matter of policy to be able to effectively grant on an interim basis a sort of average median salary whilst a specific basic need application is considered. I'm also instructed that it is considered very important for Ofsted to be able to scrutinise the basic needs applications very carefully for reasons of risks of sanction avoidance and evasion and so on and so forth.
Yes, but you understand the point that
I do
concerned the
understand
court yesterday, that
I do understand the point.
from the moment you're designated, even if you happen to have a cash in the safe, which you may or may not, you can't spend it lawfully.
Yes.
And you haven't yet answered the question whether at the moment of designation, either you are given some interim basic needs license, or, query whether this is good enough, are told, well, I'm sorry, we'll get round to your basic needs as soon as we can. In the meantime, spend what money you've got and we promise you won't prosecute you.
Yeah. I can't, there is no system, for example, like with a freezing order that my lord had in mind, where you have effectively, I think in the case of freezing order, you have set wording which makes provision for living needs.
But I mean, given that these matters are now coming up to the courts and being looked at,
Yes.
the only reason freezing orders got to a level of humanity was because the courts realised they weren't working properly in that respect. And this is to give you the opportunity, before we say anything, to ensure they operate humanely.
Yes. I entirely understand the point. I can only tell the courts the position as it is as a matter of
Well,
fact.
I think, speaking for myself, I think it would still be helpful to have a note.
Yes.
Whether we think it appropriate or necessary to say anything about this particular aspect. This particular aspect, what the position is at the moment of designation, doesn't arise because the decision challenges the Pope. But it's a matter of some public interest and some importance to the court.
I entirely understand.
And I think an accurate note on the basis of which we may say something
Yes.
is important that we have.
Yes. I entirely understand. I'm sorry I can't give the court that accuracy of information. As I say, the information was given to me in an email.
But you do understand what the criticism is, because the potential criticism is the kinds of points you were addressing so far didn't really go to the heart of it.
No, I entirely understand the point. I understand.
Can I ask one further question
Yes.
about Ofsted? And that's simply this. It's clear that there are certain internal, we can see from just the decisions we've seen, that there are certain rules like the NHS is good enough except in exceptional cases. State education is, it's appropriate not to allow people to spend money on private education, again, except possibly in exceptional cases. Are these policies set out anywhere? You showed us the guidance,
I think my learned
but
friend.
the guidance didn't appear to deal with them, unless I missed it. Or was there even any general statement of principle about you should live? One, you can't expect to go on living at your previous lifestyle. That's part of the point of sanctions.
Yes.
Two, the standard at which you can expect to live is ... Because otherwise, I mean, how do you decide how much food people are allowed? Or is it on the basis that they should be at the level of minimum wage? I just don't know.
No. Well, this may be something I can cover in the note, because there are also, for example, a number of general licences which do apply from the start. So the moment you're designated, you're subject to a general licence. For things like, for example, utility provision, local authority bills.
If you're,
travel to
okay,
Russia.
I don't want to know the detail, and we haven't
No.
time for it now, but is the caseworker given some sort of guidance? These are the principles we follow. Utility bills, I don't know, I have no idea. I can't imagine it's done ad hoc in each decision, so I suspect there is some guidance. Is it public?
Well, can I come back to that in the note? The reason I want to is because it's not my clients. I'm not acting on behalf of the Treasury and Office. And so it's difficult to get the instructions overnight in this case. I have tried.
Yes.
I can
Very
reassure
well.
the court we have asked the question.
I think we've got to leave some time for reply.
Of course, I'm
unless my
conscious.
lords want to pursue either that or any other aspect.
Can I just for a moment turn my back and check my notes as well? I think I've covered everything.
Yes, my lord reminds me,
Ground
ground 4.
Yes. So the short point on ground 4 is Ahmed, and indeed the Strasbourg cases that are relied on ground 4 that you weren't taken to yesterday, so Nada al-Dalimi, are very different cases. They are cases about sanction designation by list, where the domestic authorities are giving effect to a decision to include somebody in a list by a higher international actor, so the UN. It's usually the UN, Al-Qaeda and ISIL sanctions list. Varies over time. And the problem is that the effect, for example, in Ahmed, of the orders was to remove any effective access to a court, because any judicial review you had, and I appreciate my lord particularly will know this, wasn't effective in taking somebody off the designation in terms of the UN list. And that was seen to be ultra vires, the enabling powers for the orders, in the UN Act 1946. Now, Youssef decided that, in fact, the position under the sanctions regime now with Samler was acceptable, because you have parliaments actually stepping into the void and saying this is how you regulate access to the court in section 38. But in any event, the more fundamental point of distinction in a case like this is that if you challenge through the courts your designation, the courts can effectively take you off the list by quashing the designation. So it's entirely effective judicial review. It doesn't suffer from the flaw that was operative in Ahmed whatsoever.
I think there's a distinct argument within this, Ms Montgomery made yesterday, which is that if the law is that there is, for example, considerable respect due to the Secretary of State's assessment on fair balance, for example, that is ineffective judicial review. I'm not saying it's a good point, but that was one of the ways. That's one of the ways in which it's been put, which is different from what you've done so far.
Yes. So the answer to that is domestically Alconbury and that line of cases, Alconbury and then Begum in the Supreme Court, and there's a variety of other cases as well, and in Strasbourg, Ali. We've given you all the references to those cases in our skeleton argument. Let me just give you that reference again. Yes, so it's paragraph 65 of our skeleton argument. We give you the references to Runa Begum in the Supreme Court, which is
We can
take
find
on.
the references there.
Yeah.
Yep.
And we also make points about the way that you can, for example, find facts even in JR. Marla, just to answer one question I was asking afterwards about the annual reviews. So you'll recall a point
Yes.
that Phillips' 3 years. I'm told that was removed, that provision, by section 62 of the 2022 Act.
Thank you very much. That section has a lot to answer for. Thank you very much.
I'm grateful.
Ms Montgomery, time is short. On the other hand, a reply is only a reply, and you are, I know, extremely succinct. If necessary, we will run over by a few minutes, but only, I'm afraid, by a few minutes, because one of us has another meeting.
Certainly. My Lords, I'm going to say nothing more about Padfield. The reality is, however, that we do submit that the original statutory formulation of a requirement to consider whether sanctions are appropriate remains an obligation, if not under the head of Padfield, then at the very least at the point of considering either rational connection or in accordance with, or proportionality. So at some point, the court, in reviewing this decision-making process, has to confront the issue as to whether or not, given the likely effects of the designation, is it appropriate to sanction where those effects are likely to be limited.
Yes.
Secondly, can I turn to human rights issues and deal briefly with accordance with the law? Firstly, the Secretary of State suggests that the definition of associate is funneled down. If that is intended to suggest that the references to financial benefit and immediate family members limit it, it's not. As the court notes in Dalston, that is an inclusive definition, not a complete one, and therefore all that the provisions in relation to family membership and benefit do is provide some core meaning, but they do not limit the width of the term associate. It can be anyone for any reason, provided it falls within the language of associated with. And that's why it doesn't catch, for example, or doesn't prevent associates of associates. And indeed, those can be by reason other than family connection or financial benefit. So in our respectful submission, if one is starting with that you have an extraordinarily wide category that could be exponentially wider than the principal players, it is not sufficient for the purposes of foreseeability for there to be any reliance upon the pre-designation requirement to assess proportionality, or indeed the post-decision rights to challenge the decision either with the Secretary of State or in the court. And the reason that's not sufficient, and indeed those remedies were available in Bridges, the reason that type of protection does not satisfy the requirements of proportionality is for the reason that Bridges notes, and I should just take your lordships to this, so it's volume 2, behind flag 16, at page 743. And it's the one paragraph that Mr. Blundell did not read at the bottom of the page, and particularly the last 3 lines. The measure must also be foreseeable, meaning it must be possible for a person to foresee its consequences for them. And that means that one considers whether this measure is foreseeable by asking, how can one of the myriad of associates or associates of associates work out whether they're going to be chosen for designation or consideration of designation, and if they are chosen for that consideration, why then? And if one is indulging in the sort of mathematics which ends up with the respondent saying this is nowhere near Bank Melag, Bank Mellat, it was one of 26 Iranian banks that could have been targeted. I take the number from the report.
Bank Mellat wasn't, in fact, decided on
It was proportionality. Yeah. But this point, even if I fail on in accordance with the law, it's going
you
to
redeploy it under proportionality.
indeed. I mean that's part of the reason why,
Yeah.
as my lord says, it's difficult to criticise the judges because these points all do re-emerge in different forms, but with a different legal analysis. But the Bank Mellat point is simply this: one of 26. In terms of the numbers, and these are not wives, these are all associates, 48 of over 1,500. So it's exactly the same proportion. And indeed, as we know, in fact, the category of associates, if you have 1,500 players, there are probably 100,000 associates.
We got the point.
Finally, and I'm going to deal with this really under fair balance, there's been a lot of concentration on the money this morning. And that is a classic example of why, if the money was so important, if a lawful transfer pre-sanction was regarded as being a trigger that might cause an associate designation, then there should be guidance to that effect, because then a person can say, don't give me anything. If you give me anything, that will lead to me being subject to sanctions. Or even now, if it is just about the money, that you could set, it would be perfectly easy to set up a structure which says, you're worried about the money going to Russia, I'm going to put it all in a blind trust, I can't touch it. And so if that is the only reason, not only are you entitled to know that, but in terms of lesser measures, that's a classic example where some measure falling short of sanctioning would be available if that was in truth the real reason that lay behind the decision making in this case. And I say in truth the reason that lay behind this decision making because they had no idea about that money. As we can see, tracing through the original decision making, one of the points that's made to the minister on the original decision back in April 2022 is they're going to catch £3 million in UK bank accounts. And the only reason they know about the very large payments is because Miss Khan tells them.
Did you tell them prior to the designation review?
Yes, yes. And gave absolutely chapter and verse about it.
That appears from the review itself.
Yes. So, just to deal very briefly with the points, Malone Friend says, judge made her own individualised decision. The reality is, as my Lord Justice Singh points out, the passage she quotes from Mrs Justice Garnham is exactly the passage that appears in Dalston and is said to contain the error of reasoning. And there is no point at which she refers to the correctness of the decision in her own judgment. It is always referred to through the prism of the correctness of the Secretary of State's decision. Secondly, some points have been made about what one can infer about the importance of Mr. Khan as a player. I do just need to make this point. That meeting in March 23 was not a select group of 6 or so oligarchs. We will give the court the newspaper report. There was, in fact, scores of people there, and it is the only evidence of any direct connection between Mr. Khan and President Putin that has ever emerged.
Well, was that before the judge?
It was the full report.
Okay.
The full report was before the judge. So I'll hand it up now, but you can see.
Oh, the usher can.
There's a photo
Usher.
and.
Usher. Hello. Could you kindly?
You can see there's at least three rows of seating in suits looking at him. It's not a handful of people.
Right, we have that point.
Yep. The next point I would respectfully make is that it would not be open to the court for some of the reasons I've already mentioned to remake this decision on the basis that the justification for designation and indeed maintaining designation is in relation to the sums of money that were received. That if that is the basis for designation, that has never been made apparent. It was not described in the original decision. It does not feature in either the administrative review form or the sanctions designation form.
So I don't understand that submission. If proportionality is a question for the court,
Yes.
and on your submission, it has to be for this
Yes.
court because the High Court judge
Yes.
erred in law.
Yes.
So we have to do, as per Schwidler, the exercise
Yes.
for ourselves.
Yes.
Then why can't we take that into account?
Because it would, in my submission, be grossly procedurally unfair. Because, as I say, in fact, if you are going to do that, and that is the focus of this designation, that, as I said just earlier, that is clearly a problem that could be dealt with by lesser measures.
Well, that may be a submission that we would then take into account in deciding whether proportionality has been or not made out. But what I'm not understanding is why it's unfair.
So it's not conceptually unfair, but in terms of the preparation of the case, this case has been prepared, providing you with evidence that has sought to address the points made on behalf of the Secretary of State in his decision-making process. And Miss Khan has given a very full and frank account about her receipt of those sums of money. If it were to be considered that she is at risk of committing what your Lordship described as some sort of private arrangement, or committing herself some private arrangement with Mr. Khan, it would have been possible to deal with that in much greater detail. Of course, I can say to you she's a woman of good character and nobody's ever suggested that would happen. Indeed, nobody has ever suggested that would happen. And on the circumstance that your Lordship described to Miss Blundell, it would clearly contravene Regulation 19, the anti-contravention offence.
But we were told it wouldn't.
Well,
That's why they need to designate.
It plainly would. Your Lordships have got Regulation 19. It is, in the clearest possible terms, capable of being construed so as to catch a sanctioned husband saying to a sanctioned wife, see if you can send me stuff so we can invest it in Russia. And apart from anything else, my lord, again, a point that we could have called evidence on, how the putative investment in Russia is supposed to take place when Russian banks and indeed most Russian businesses are themselves subject to sanctions, whether UK sanctions or elsewhere. It is quite hard to conceive in practical terms how an unexpressed but present wish to use money sent by Mr. Khan to send back to Russia could possibly take place.
I'm sorry, Mr. Montgomery. Regulation 19, page 33, is about circumventing prohibitions.
Yes.
Mr. Blundell's fundamental submission on this was that it's not about circumventing the prohibitions. What I understood him to be saying was that you might forget about investing in Russia. That a husband and wife would be perfectly free to speak to each other and perfectly in good faith might be given advice, well, this is I suggest you invest this money in this way. And if the wife is not designated herself, he submits, and he may be wrong about this as a matter of law, but he submits that there would be nothing in law to prevent that sort of investment taking place.
So the discussion which I think your Lordship envisaged and which Mr. Blundell answered was the husband saying to the wife, take this money and you can then use it so as to assist me to evade sanctions.
No, I'm not envisaging that at all.
Well,
I'm envisaging just what I've just said,
well,
which is just a normal conversation between married people. Wife says to husband, I've got this money. How should can you give me any advice on how I should invest it?
Yes. So assuming she's not sanctioned,
Yeah.
that is a perfectly lawful activity.
Exactly.
And therefore, why should one use designation to prevent it?
Well, that's a different point.
Well,
The
because
argument, I think, was put that President Putin said to all the billionaires, invest in Russia.
Yes.
And then the putative discussion
Yes.
is between husband and wife, look, darling,
So-
Aeroflot shares are crashed and
Yes.
burned at the moment, it's a good investment.
yes, and my non-putative answer
Yeah.
is on the evidence. There is no indication that that would be her intention. She's expressed very clear political views.
Yeah.
She's expressed very clearly, but in private, her husband's political views. But more importantly, it would simply not be practicable for her to invest in Aeroflot in any meaningful sense. The mechanisms for financial transfers between Europe and Russia, although this is not in evidence, it's a matter of common knowledge, are completely severed. So if that were to be the proposition upon which this designation stood, I would say there's simply no factual basis for making that assertion.
You say this is all matter which could have been put in evidence if only this had been part of the evidence below. But Mr. Reid 71D does say, 72D, material risk that he could mitigate the impact of his asset freeze by holding assets through and moving assets into the name of his family members. This is very common. We assess the likelihood of this risk materialising is increased by the pattern of his past behaviour, specifically giving her lots of money, and that he did so, naming the sum, in March 2022, shortly before he was designated.
Mr. Reid is making a point about circumvention,
Yeah.
a real Regulation 19 offence, for which there is no evidence. The only transfer was a lawful transfer, not a circumventing transfer. And there is no material to suggest that Miss Khan, undesignated, would nevertheless go on and commit a circumvention offence. Because that, Mr. Reid is not talking about my Lord's example, darling, invest in Aeroflot. He's talking about Miss Khan committing a criminal offence to benefit Mr. Khan, who is designated. And there's simply no evidence of that.
Okay, thank you. Right. Other key points you would need to make? That's obviously an important one.
So, one other key point, I suppose, because it's featured a lot. The court, in setting the fair balance, in our submission, has to concentrate on the actual effect of the measures and not on the theoretical operation of them in some idealised circumstances. Because the decisions that are made about fair balance must include the system of sanctions as it actually operates. As it actually operates, I can tell you, Lordships, and you've got the detail, the person who is sanctioned because there is no automatic basic needs licence is required to commit sanctions offences in order to pay for food to eat. And we have given you the timetable
Yes.
of the sanctions basic need licence in...
As you say, this is all in the evidence.
I'm just going to give you the reference. It's in
Yes.
X, beginning at behind flag 282, which tells you she was sanctioned in, as you know, 22nd of April, and she doesn't get a basic needs licence until the 8th of June. And in the meantime, she has to write confessing she's committed criminal offences. And one other point.
And we don't know, do we? It's not crucial, but we don't know whether she was given advice by OFSI that if you want want to avoid prosecution, you better write us a letter.
She wasn't.
No, she didn't.
We've got the letter here that she was sent. It says nothing other than you'll commit criminal offences if you spend any money from now
Well,
on.
I think it would be sensible if we saw that letter.
And that was in the trial bundle as well.
I don't think this was, my lord.
Well, I think in the circumstances, Mr. Rundle, you can't object to us seeing it. If it wasn't in the bundle, but
No.
it's clearly a part of the.
No
policy
objection, and indeed that was one of the documents that was sent to me by OFSI earlier.
Oh, I see. Right. Well, there we
would
are.
Suggest you sort of-
Okay, we won't spend time looking at it now, but the point is it's simply to make good your point that she is compelled to commit a criminal offence to eat.
She did commit a criminal offence.
Yes, well,
In circumstances where there was no guarantee that she wouldn't be prosecuted.
Yeah.
And just last thing, your lordships have assumed that there was no complaint about the Office sanctioning process at the review stage. There was. Again, you've got very substantial material about it. It is, as I said to the judge below, a system that remains unfit for purpose. Given the time, my lord, that's all I can say by way of reply.
Thank you very much indeed, Ms Montgomery. Thank you.
Sorry, could I mention one thing? I'm assuming your lordships aren't going to hand down judgment today.
You're assuming correctly. I was about to tell you that.
Since there is going to be potentially an issue about privacy and confidentiality, would your lordships, when you provide a draft judgment, allow us to show it to the client? Because obviously we'll need to take instructions immediately rather than delay showing it to her in the usual way.
Well, in the usual way, you normally do show it to the client, don't you? So
sometimes the client has a limited window, but we need to show it.
I must say, I would assume that you would show it to the client. And yes, I'm happy to make that clear on the understanding of its confidentiality and of the importance, which I'm about to tell you in the form of words that we're all used to, of not breaking the confidence.
Yes, indeed.
Yes. Well, look, in the circumstances, perhaps I won't go through the usual rigmarole. You're both very experienced. Please do impress on those behind you, particularly on lay people, the importance of the principles in the Counsel General for Wales case, and that they could get into serious trouble if there's any breach of the confidentiality. Thank you very much.
All rise in favour.